Does a will written in one state govern the inheritance of land in another state? The United States Supreme Court inherited this issue when it took up the late 19th century case of Clark versus Clark. Julia Clark, a South Carolina resident, died. Julia was survived by her husband Henry and two daughters, 5-year-old Nancy and a 2-month-old also named Julia. Baby Julia died a few months later. Mrs. Clark's estate included real and personal property, including real estate in Connecticut. Mrs. Clark had executed a will before she had baby Julia. The will's residual clause directed that the residue of her estate was to be shared equally between Henry and her children. Henry Clark, as executor of his wife's estate, sued his young daughter Nancy in South Carolina State Court, seeking the court's directions regarding the construction of Julia's will. That court ruled that Julia's will worked an equitable conversion of the Connecticut real estate into personal property. The court directed Henry, as executor, to sell the Connecticut property and apply the proceeds to his wife's estate. So Henry and Nancy would share the proceeds of the sale equally. The South Carolina Supreme Court affirmed that decision. Henry then petitioned a Connecticut probate court for leave to sell Julia's real estate as directed by the South Carolina court order. The Connecticut court applied Connecticut law, ruling that Nancy was baby Julia's sole heir. So Nancy was to inherit the entire Connecticut real estate. The Connecticut Supreme Court of Errors affirmed the probate court's decision. The United States Supreme Court then granted Henry's petition for a writ of error.